Welcome to Rightly Decided, the mostly original originalist takes of the litigators of the Texas Public Policy Foundation. I am Laura Beth Latimer, and I'm here with our Director of Litigation, Chance Weldon, and the newly barred youngest SCOTUS attorney in the room, Mr. Clayton Calvin. Clayton, you got sworn in last week.
I got sworn in to the bar of the Supreme Court of the United States.
What is that
of America.
Like, what is the process like?
Well, it's amazingly humbling, and it's an amazing honor. It doesn't mean you have to have won all the cases, but in terms of qualifications and everything. But TPPF was kind enough to sponsor and move me in, and it was amazing. We saw all 8 of the justices. Kagan was not there, but we saw them all in the flesh, and we swore our oath, as it were. And
put your hand on the Bible, said.
Yeah, well, put our hand in the air, but
yeah.
It was awesome to be in the room and there, and so now I can file briefs for TPPF.
That's amazing. That is so exciting.
Doesn't SCOTUS smell like an old church? It kind of vibes that way.
Yeah, I mean, a lot more.
I think that's dust. I think the word you're looking for is dusty.
Yeah, but there's more. There's marble everywhere and big windows, and I mean, you're really there in that historical place, and and it's humbling though, because it's the court is carrying on and just doing its duties, and they're real people, and even right there in that hallowed place, it was very humbling.
That is so cool. We are so excited for you.
Thank you.
And you also had the opportunity to be there last Thursday, and we're now in the month of June, so we get Thursday drop days. Mm-hmm. And you got to hear some cases being read from the bench. So
we did.
Okay, I think there was some misconception about what happens when the justices read from the bench. So how does that work?
So it was right before the swearing in component. So they get there, I think it was 10 o'clock in the morning, and then they just start reading. They didn't read the entire case out loud. They just read the syllabi for each case.
Okay.
And it was the author of each opinion that read the syllabus for it. So I think that day we had Roberts, who read the syllabus for one of the cases we'll talk about today, the FCC case. Jackson started off the day. It was I know this case is very important in terms of its real world impact, but just in terms of it was such niche technical legal issues involved. I think it was a patent pharmaceutical case. Yeah. And so you're waiting for birthright citizenship or something. We're sitting there, and then she says, and then she starts talking about that subject. So
she was
like,
kind of and patents, and people.
I was like, okay, well, certain people will be very attentive to this. And then there was a third case. I want to say it was Gorsuch.
Yeah, I think there was another unanimous. All 3 opinions I think that came down were unanimous or close to unanimous.
Yes, except for this
FCC case that we'll talk about in a little bit. But before we get to the FCC case, let's go back a couple of weeks. There were 2 cases that were released, not this Thursday, most recent Thursday, but the Thursday before, that I'd like to talk about. The first one is Flower Foods. This one has gotten some media attention, but not a whole ton. This was a Gorsuch opinion dealing with the Federal Arbitration Act. Mm-hmm. And basically, the Federal Arbitration Act is a law that allows federal courts to enforce private arbitration agreements with some exceptions. And this is a case dealing with one of those exceptions. And that exception is for workers, and I want to get this language right, workers engaged in interstate commerce. Yeah. So it's already kind of a weird law, because I assume the FCC or the FAA was passed under the Commerce Clause.
Yeah, so it's what is this exception? Everything that the law covers?
Exactly. Everything that the light touches is accepted from this law.
Is both regulated and exempted from the regulation.
Exactly. At the same time. So the question that came in front of the court was this question of last mile drivers, right? It's where we have these out-of-state products that are being transported into state, into some sort of warehouse situation, and then they're transported from that warehouse to the ultimate distributor. That person who drives that purely intrastate mile to get from the warehouse to the distributor, is he engaged in interstate commerce such that the Federal Arbitration Act doesn't apply? That's the question that the court was asking.
For people think about Amazon, right? You buy something off of Amazon from Kentucky, it comes to the Amazon warehouse here in Texas, and then it goes into one of those neat little blue vans that drives it to your front door. Mm-hmm. The question is that last mile that it's driven in that little blue van outside of interstate commerce, and therefore...
And even, and in this case, it's even less apparently connected to interstate commerce, because I think it was just a local company.
Yeah.
It didn't say Amazon on it, for example.
Yeah.
It was like a local distributing company.
Yeah. But Flower Foods is huge. I mean, Flower Foods is an international brand, I think.
Yeah.
Like Honey Bun, I think.
Mm-hmm.
This morning, I got into my car to drive here, and my husband had left a Honey Bun wrapper on the other seat in my car, and I was like, I should bring that in for story time, but I didn't do that. But yeah, so this is an interstate organization company, like the big overarching company is obviously interstate. There's no argument about that. There's also no argument that last mile that this particular driver in question was driving was intrastate. He was not crossing state lines. So the question is, does the FAA apply? Does the exception apply that would allow him to opt out of the FAA?
Right, because he wanted to bring an employment services suit against Flower Foods, and Flower Foods wanted to just dismiss that suit because of an arbitration agreement and go to arbitration instead because of an agreement that they had. And and he didn't want that, obviously.
And then Gorsuch, on behalf of the unanimous court, says, yeah, no, this absolutely applies. He is absolutely engaged in interstate commerce.
And therefore doesn't have to go to arbitration and can bring the suit.
And therefore he can bring the suit.
Yeah.
So we here at TPPF do a lot of Commerce Clause stuff. We talk about interstate commerce in almost every breath, I think. Did this case make us run crying into our bedrooms to hide our heads under our pillows, Chance?
No.
Why not?
Well, I mean, because most of the mischief that we think of when we talk about the expansion of the Commerce Clause dates back to a case called Wickard versus Filburn. And for those of you who didn't suffer through law school or enjoy law school, or even those who did.
Even if you did, you suffered through Wickard.
Yeah.
Yes.
Wickard was this case where the court or the federal government during the Great Depression had prohibited farmers from growing wheat. It regulated the amount of wheat that you could grow and consume. And the farmer in that case was not growing the wheat for sale. He was growing it for personal consumption, I believe, to feed his animals on his property. And the federal government prosecuted him anyway. And they said that even though you weren't buying or selling goods, the production of that wheat was basically, you would have otherwise had to have bought wheat to feed your animals. And therefore, if everyone did this in the aggregate, it would have a substantial effect on wheat markets. And therefore, that is a regulation of interstate commerce, even though we're literally just regulating you eating the wheat that you grew on your own farm in one state.
We're penalizing you for eating your own wheat on your own land.
And this created what's called the substantial effects test, which is the most far-reaching and, from an original public meaning perspective, crazy application of the commerce and necessary and proper clauses. And we've found a lot of cases that over time have tried to chip away at this really aggressive reading of the Commerce Clause. Most originalists think that Wickard was wrongly decided. And so a lot of folks, when they see this case, they're like, oh, well, this must be just another, application of Wickard. But it's not. It actually has nothing to do with the substantial effects test. This case was from a statute in the 1920s. It's interpreting this 1920 statute. Yeah. And it's really applying the older, more traditional view of what engaging in interstate commerce is. Going back to these cases in the late 19th and early 20th century, an item was thought to be in interstate commerce from the time that it was packed up on the vehicle, to the time it reached its endpoint destination and was opened by the consumer. Everything on that trip, even the little intrastate legs of that, were all considered interstate commerce. It was point A to point B. And that was a well-established view of the Commerce Clause.
And even though that might sound kind of broad, I mean, you can see both sides of it. That's a plausible understanding, but also kind of broad sounding. But it's still a different thing altogether from saying things that could hypothetically, potentially affect interstate commerce if you were to do them, even though you're not doing them.
Yes.
This is different. This is you are actually engaging in interstate commerce sometimes, even if you're within a state. If I'm shipping something from Austin to New Mexico, it's going to go 7 hours through Texas before it gets to New Mexico. But that leg is still part of
interstate commerce
that's going to the other state. Yeah.
And that word engaged is doing a lot of heavy lifting here, because it's not necessarily talking about what is commerce. It's what does it mean to be engaged in commerce? What does it mean to be engaged in this process?
Right. Not
So-
substantially affect commerce,
Right.
which is broader, but
But
engaged.
to actually be engaged in it.
Yeah.
And if I am handing something to you and then you are handing something to someone else, we are engaged in commerce.
Yeah.
Even if I'm the one who runs across the state line and then hands it to you, we are as a network here engaged in commerce. So
Right.
It's a fundamentally different than saying I'm merely possessing this thing and somehow I'm substantially affecting commerce.
Yeah. And this isn't a situation where, maybe somebody bought lumber from Tennessee and then the lumber gets there and they unpack it and then they start, they decide that they're going to use that lumber 6 months later to build tables and then they only sell those tables in Tennessee.
This is like it's being delivered right now.
Yeah. This is the delivery. This is like one continuous kind of order to delivery, one line that just happens to have intrastate legs on it.
Mhm.
And the cases on that really, like I said, go back to the late 19th century, early 20th century with trains. You would have like the shipment would come here and then you'd get a new engine to pull it in one state. But that doesn't mean that the trip is a different trip. It's still the same trip, even though it has.
Yeah. I think Gorsuch used the example. I mean, basically, he said this hypothetical is actually not so much of a hypothetical because it was like basically the facts of this case.
Yeah.
He's saying, if you're shipping something to another state and you hire 3 people to do it, one of the people is going from where you are in state A to the border, and then the second person carries it 10 feet across the border.
Yeah.
And then a third person carries it the rest of the way within state B. It's not like you're going to say only that second person was engaged in interstate commerce because he was the one who crossed the state line. Like the whole thing is.
The whole thing is one trip.
Yeah.
It's all really one trip. And I think it's interesting that, justices that hate Wickard. I mean, Justice Thomas, going back to Lopez and maybe even before that, but most famously in his concurring opinion in Lopez, has for years railed against the validity of Wickard and the substantial effects test in general.
Mm-hmm.
And even Justice Thomas joins this. This is not a substantial effects case.
Yeah, right. Well, because it's not a constitutional case.
Yeah.
So this is not a Commerce Clause case.
Yeah.
This is what does the term engaged in interstate commerce mean under this statute for purposes of exempting someone from the statute.
Yes.
And not being regulated. So it's not going to have a big ripple effect on the constitutional jurisprudence about it, except to expose and betray what really just how broad, disingenuously, as we think, broad the scope of the constitutional Commerce Clause jurisprudence is, because it's so much broader than things that are actually engaged in interstate commerce as interpreted under this statute. So I don't know, maybe some creative public interest attorneys could point that out at some point.
Absolutely.
Mm-hmm.
Yeah. Maybe we could work on it. Maybe with some cases about like guns or something.
Yeah.
Maybe.
Yeah.
In the Northern District of Texas.
Yeah.
Hypothetically speaking.
Hypothetically speaking, if you're interested, it is Texas Gun Club versus Blanche. Gun Club versus Blanche. Yeah. Has it been changed already?
I think it's been changed.
Okay. So let's move on, because we don't have a ton of time to cover all 3 of these cases, to Pitchford v. Cain, which is a death penalty case that came down on the same day as Flower Foods. Mm-hmm. And this revolves around a Batson challenge. So Batson is an equal protection case that essentially says it is prohibited for prosecutors to use what's called peremptory strike. So strike without the court saying that there's a problem with the person involved.
And you get 4?
Oh, it depends. It depends.
Okay.
It's actually there's so much debate about this. It varies from court to court. It can vary from trial to trial.
It's a jury selection, though. We haven't we're already jumping to Batson is a jury selection.
Batson is a jury selection issue. Yeah. So prosecutors and defense attorneys get the same number of strikes to say these are people. Okay, let me go back to the process of jury selection.
Former prosecutors.
Yeah. Sorry. We'll go back to the very beginning. The process of jury selection. When you show up for jury duty, you're put, usually we'll say there's 100 people that are summoned. They'll send out 1,000, 100 people show up. And those people will sit in a big room, and the first 12 people are your jury, right? And if we were allowed to ask no questions and the judge was allowed to do no qualifications, those first 12 people would be the one who go and sit in the box. However, because we believe in something called justice and having fair and impartial jurors, the judge gets to qualify the jury panel and ask questions of the jury to make sure that everyone there can be fair and impartial.
You don't want someone's brother or cousin sitting on the jury.
So it's
Or like
it's
a
the,
serial killer.
Are you a felon? Are you qualified to sit on this jury? In Texas, have you committed an act of theft, which is a really funny one? If you get convicted for shoplifting in Texas, you can't sit on a jury. Fun fact.
Well,
Yeah. So there you go. There's how you get out of jury duty, folks.
Exactly.
So that's like the initial qualifications the judge does. And then the prosecutor, as the state, gets to stand up and ask questions of the jury panel. And then the defense gets to stand up and ask questions of the jury panel. And then they get to, first of all, argue with the judge about who gets struck for cause. And some people, as the prosecutor or the defense are asking questions, they will say things like, well, I just believe that everybody who commits any act of violence is always going to commit another act of violence. And so I've decided that this guy's already guilty because he's been accused, and he just things like that, And the judge will dismiss those people for cause. But sometimes you get people that say things that make the defense go, I want that guy on my jury, and make the state go, oh, I really don't want that guy on my jury. And so we have peremptory strikes, which is the process of saying that's a person that I, for whatever reason, don't want sitting on this jury. I think they will make this jury less fair and less impartial.
And the parties get to do this. They get to strike the juries that they
And the
want
parties
to.
get to strike.
And it's generally for any reason that it's like can be subjective, or there's some limits.
Yes. It is pretty much with the caveat of
Race.
The Equal Protection Clause applies. So it's not just race, it's also sex. So we have Batson challenges with respect to sex. That's a whole other issue entirely. But if you are dealing specifically with race, Batson says the state cannot use peremptory challenges to strike jurors on the basis of race.
So you can't say, I don't want any black people on this jury, or I don't want any white people.
Black.
Because they're black, that would violate the Equal Protection Clause.
And importantly...
Do that?
So that's called yes. Okay. Yes, it's called a reverse Batson challenge. Okay. That's a different case later on. There is so much progeny out of Batson.
Yeah.
But yes, so it does now apply to the defense as well. But Batson is specifically the state. Prosecutors cannot strike people on the basis of race. Interestingly, the reason for that is because it violates the equal protection of the proposed juror. So it doesn't matter what color your defendant is. It matters if you are intentionally striking someone because of their race. So that's
the state, because the state full stop's not allowed to do that at all.
Right. That makes sense. Way more information about Batson than you need for purposes of understanding this case.
We learned a lot today.
There is a whole process for a Batson challenge. When a defense attorney believes that the prosecutor has used a peremptory strike on someone who is of a different race, whether that person is white or black or Hispanic or whatever, I believe you struck this person on the basis of race. The burden then comes to the state to put forward race-neutral reasons. And then the burden shifts back to the defense to show that, no, those race-neutral reasons are a fake, basically. It's a pretext. It's still just race. And there's a series of ways that you can prove that it's a pretext. Most often, the way to prove that it's a pretext is by ratios, by saying, yeah, you can say that, but you struck 9 out of 9 potential jurors that were this race from this particular jury panel. Yeah. Mm-hmm. That's usually how that goes. So in this particular case, in Pitchford v. Cain.
But there's also comparators, right? You would also say another way you would get around that would be not the ratios way, but the way of saying, oh, you say that you struck this person because you don't want any plumbers on the jury, but you have 2 white plumbers on the jury that you didn't strike. Right. Yeah.
Yeah. So there's like I said, there's several ways, and actually that's the one that's at issue in theoretically.
That's why I brought it up.
In this case. I appreciate that, Chance. This was a death penalty case where the defendant raised a Batson challenge, and I'm going to read from the court's opinion how this goes down, because I think that it's important to get it right. During jury selection at Pitchford's trial in Mississippi State Court, the prosecutor used peremptory strikes against 4 of the 5 potential black jurors. In response, Pitchford's counsel raised a Batson objection. The trial court asked the prosecutor for race-neutral reasons for striking each of the 4 black potential jurors. According to the prosecutor, 1 had returned 15 minutes late to court, 2 others had brothers convicted of violent offenses, and the 4th, like Pitchford, was young, unmarried, and a father. As the prosecutor offered reasons for striking each of the jurors, the trial court declared each to be race-neutral. Upon hearing the prosecutor's reason for the last strike, the trial court stated that the court finds that to be race-neutral as well, and pivoted immediately to the defense's peremptory strikes. At that time, the trial court did not afford defense counsel an opportunity to rebut as pretextual the prosecutor's race-neutral reasons for striking the 4 black jurors, nor did the trial court make any findings regarding whether the prosecutor's stated reasons were pretextual. In other words, as the U.S. District Court later explained on habeas review, the trial court full stop ended its Batson analysis at step 2 and never proceeded to step 3. At the close of jury selection, defense counsel sought to raise the Batson issue again, but the trial court twice cut off defense counsel and extended the inquiry before counsel could try to rebut as pretextual the race-neutral reasons articulated by the prosecution. This is the quote. "I think you already made those, and they are clear in the record. For the reasons previously stated, first, the court finds there to be all the reasons were race-neutral as to the members that were struck by the district attorney's office, and so the court finds that there is no Batson violation." So that's how the court frames this. We have...
So they brought it up and they said, hey, we think that those are... they didn't make an argument. They just sort of like preserved their objection, basically.
So yes. The question is, were they allowed to preserve this third step of Batson? Was that particular thing preserved?
I think it probably makes sense to unpack for the audience why that even matters. So typically, if you want to appeal something, if you want to run something up on appeal, particularly to the Supreme Court, you have to have raised it and preserved the issue in the district court. Mm-hmm. You can't argue a bunch of new stuff.
Yeah. Appellate courts exist to look at the record below and then make another.
And so the question here really isn't about the validity of the Batson challenge that he wanted to raise. It's about, was that enough, that sort of like timeline she just put out, was that enough for him to preserve this particular argument or not?
Exactly. That's the question that's in front of the court is, was this preserved for purposes of appeal? And I do want to flag as well, one of the important reasons, if not the most important reason for the preservation rule is because we want trial judges to get it right the first time around. We don't want to have to keep coming back and redoing things that the parties didn't ever draw attention to. Yeah. And so by flagging an issue, by saying objection judge, and then giving a clear enough objection that the judge could in that moment have done it the right way, that's what we're looking for preservation purposes.
And what would that have looked like here?
I think that what that would have looked like is pretty much exactly what happened.
And then the other side of the argument is that they should have specifically gone into Batson step 3 and said, these are pretextual and here's why.
Yes.
And they're saying, oh, but the court didn't give me the opportunity to do that. They kind of shut me down and they said, yeah, you already preserved that. You already noted that. The record is there. But the defense counsel didn't actually get to say the reasons for thinking that these things were pretextual.
I don't even think that so there's 3 dissenters in this who we'll get into the dissent in a minute. I don't even think that they were necessarily looking for the reasons that this was pretextual. I think they were just looking for defense counsel to say step 3 or to say that's a pretext or something along those lines before the judge completely cut off that conversation. Mm-hmm. It is not unheard of for attorneys to say, Judge, I hear you. I recognize that you are overruling my objection. I'd like to make a record. Yeah. And then make a very clear objection. Not all judges take kindly to that. Mm-hmm.
So to be clear, though, the Supreme Court held in this case that was sufficient to preserve the issue on appeal.
Yes. A majority of the Supreme Court held that was sufficient to preserve.
The fact that he raised Batson, he didn't have to do any additional magic words, that in that circumstance, once he had raised it and then the judge said, you've preserved it, that was enough. The fact that he didn't have to go further.
And also they acknowledged that he had been prevented from doing that.
Yeah. And I think this is probably a little bit unfair of me, but I think you can ask appellate attorneys and ask trial attorneys this same question and probably get 2 different answers about how they feel about this case. Because those of us who have been in a trial courtroom, those of us who have felt the speed at which these things move, know that this is a perfectly reasonable way for a defense attorney to say, Judge, I have objected to this. I want to renew my objection to this. I don't think it was done correctly. And the judge to say it was done correctly. We're moving forward. Requiring that attorney to use the magic word pretextual, like that is going to roll right off the brains of most people that are in the moment doing this kind of thing at full speed.
Mm-hmm. And when there's something so important at stake, like an equal protection objection, like a fundamental constitutional objection, hey, the jury selection here was racially motivated. I was like,
that's a pretty big deal.
Yeah, like you want to be able to revisit that.
It's interesting though, because I think there were two types of Batson challenges that are on the table. We talked about one is a percentage challenge where you say like just the pure numbers. And that's one kind of Batson challenge. And then the other kind of Batson challenge is this sort of comparator analysis where you walk through each of the jurors. And what the government had argued here was that the Batson challenge that was raised initially was just the percentage challenge, that they didn't raise a separate comparator challenge. And then on appeal, they wanted to argue the comparator challenge. They said, look, we were going to raise this when I stood up and said, hey, I'd like to preserve my Batson argument. Mm-hmm. And the judge said, no, we've already done that. It's already been preserved. You know, the government's arguing, well, what they were talking about being preserved was this percentage challenge that you made, not this separate comparator challenge, right?
And that I think is where the Mississippi State Court came down.
Yeah.
Was saying you've preserved the argument insofar as you've made it, but you didn't preserve an argument that you didn't make.
Yes.
But the rebuttal to that is, but he wasn't given the chance to make it.
Right.
And short of potentially pissing off a trial judge, which is dangerous for your client, if you're a defense attorney, putting your client at odds with that trial judge is dangerous.
It's an interesting question.
It's a fine line to walk.
If you've been in those courtrooms before, sometimes a judge that's particularly hostile or said, I've heard it, we're moving on.
Yep.
You know, it takes a certain amount of courage in some places and almost reckless disregard to go, I'm going to make my record,
you
judge.
You can handle the truth.
Yeah. You know, I'm going to stand up and make my objection and make it clearly so that it's preserved for the record. And, you know, you hope that good district judges will recognize that that's what you're doing and not get mad at you. But they're particularly for younger attorneys that maybe haven't had a lot of practice or, you know, a federal public defender that maybe this is their first or second case, like knowing that, you know, once a judge has told you, oh, it's preserved, you know, it's hard to say, like, I know that you just said it's preserved, Your Honor, but I'm going to go ahead and say specifically what the magic words are.
But even for experienced judges, I mean, if you are a defense attorney walking into this, you know your guy's going to get convicted. I'm not saying you do, but this is my hypothetical. You know your guy is going to get convicted for this, and you know that judge that you're about to piss off is the one doing the sentencing.
Yeah.
You don't want to do that. I'm not going to say it's malpractice. It's not malpractice to preserve an issue, but like, for the sake of the guy sitting next to you whose life is on the line, that's dangerous.
And more importantly, we don't want the system to incentivize you to have to do that.
And we don't want the system to incentivize you.
Even though on the other side, just for like structural or procedural purposes, we also don't want attorneys to be able to maybe like hide the ball or maybe inadvertently hide the ball and like bring up the issue for the first time in earnest on appeal because the appellate judge isn't there to like actually see like, was this actually racially motivated or not? Like you want it to all take place at the trial court. So you do want some kind of incentive for the lawyers to say everything that needs to be said right then. But like for the reasons you guys are saying, it shouldn't be like a hard rule that's necessary.
And it's important to remember that at this point, what we're looking at here, once it gets to the Supreme Court, is there's already been a series of appeals in the state court.
And that's where the dissent comes down on this.
Right. This is a situation where you've gone through the state appellate courts have looked at that record. They've looked at the preservation issue. They've looked at the transcript. Then the Supreme Court also looked at the preservation issue, also looked at the transcript. And now you're asking the United States Supreme Court to come in
on like a statutory there's a statutory standard for the habeas proceeding that took place that brought this into federal court. And so the dissent here, because this is a 5-4 opinion, the dissent said
6-3, I think, right?
Is it?
I think it's 6-3.
6-3.
Okay.
It is Gorsuch, Thomas. Oh, no, Barrett. Barrett also joined the dissent.
Yeah.
So it's, it's a...
This is why we need Nathan here to be our scorecard, because he keeps track of these things for us.
Yes, he does. Every time.
The dissent is concerned that, hey, the statute, we are only allowed to look at this because of what federal statute says, and the statute provides a high bar for meddling with state courts in this regard. And so we're sort of like getting too big for our bridges and like wading into this too much.
Yeah.
But 5 justices disagree with that and said no, that was their role because it's equal protection. That's important.
Mm-hmm.
I think, and Chance, you and I have talked about this a little bit, and I think we kind of disagree on it. To an extent, I sort of put this in the same vein or category as the party presentation rule.
Yeah.
Which, do you want to explain the party presentation rule?
So the party presentation rule basically is rooted in Article 3. Did you have, the courts are limited to cases or controversies between parties, and the parties get to frame what that case or controversy is, right? If you come in and you argue that, hey, this statute doesn't apply to me, or I didn't violate this statute, and you have a factual dispute about whether the statute was violated, but you don't raise any constitutional claims, the judge doesn't get to unilaterally come in and say, but I also think on my own that this statute's unconstitutional, even though no one has brought that controversy before the court.
Yeah, it exceeds the case or controversy that was actually brought.
That was actually brought. So the judge is limited to the controversy that's brought by the parties. And so it has this basis in Article 3. And then on appeal, the party presentation rule has sort of almost a due process element to it. That you have a case that's been argued, the party said these are the issues, it's gone through discovery, based on what those issues were, the record's been fully built out based on what those issues were.
The other party only got to rebut what the arguments they were presented with.
Right.
Throw new ones at them later.
And then you get up on appeal and a party, doesn't present it. And then the judge says, well, I want to decide it based on this other issue that you've not had an opportunity to rebut. And so party presentment is this standard that runs through court proceedings and especially on appeal. Like you can't even the parties can't raise new issues on appeal.
Mm-hmm.
That the court is only going to adjudicate those claims that the parties themselves have raised. They're not roving, bands of platonic guardians to resolve every dispute. Their job is to resolve the dispute that's put in front of them by the parties.
Mm-hmm.
Which is super easy to say in an abstract sense, but it gets really hairy around the edges when the question isn't, is this presented by the parties? It's how well does this need to be presented by the parties? If this is just raised in one party's header, is that sufficient?
Right. That's a separate one that's a separate question.
Okay.
Because you could be a very strong party presentment person that says, look, we are only resolving conflicts that were raised by the parties, and then have a very low standard for what counts as raised by the parties.
Mm-hmm.
So, for example, in some courts, issues can't be raised in footnotes, which I think makes sense to a certain degree. But some judges will say, well,
who has time to read all those footnotes? Let's
right.
be honest.
Yeah. But, if it's good enough to be in the brief, it's good enough to be in the body, particularly if it's an argument you want to raise. But some judges will say, well, that's enough. Like the party raised it, the other party had notice of it. That's enough to meet the party presentment principle. So you could be strong on party presentment saying, I'm only going to cite issues that the parties have actually raised and briefed, but then be more lenient on what counts as raising an issue for the first time, right?
And is party presentment like a strict, hard, like constitutional rule, or is it just kind of like one way of seeing Article 3 case or controversy? Because it's conceivable to say, hey, okay, you didn't bring this up, but like there's still a case or controversy, and I'm a judge and I can still look at this and try to resolve it, maybe based on something you didn't say, but like I'm still resolving I'm not exceeding my constitutional restriction to cases of controversy.
Well, different judges have different views, both on the party presentment principle and where it comes from. So there's not a sort of universal view of where people in this building have different views about the party presentment principle. People in this room.
At this table.
At this table, in fact, have different views about party presentment. But, just to give an example, Justice Gorsuch has sort of made a name for party presentment, which is why if you get a question from the podium, you're at the podium and Justice Gorsuch is like, well, there's an interesting constitutional question. What do you think about that, counsel?
You better take him up on it.
Yeah.
Because if you say, oh, well, it's not briefed or we haven't reached it, or, you'll get an opinion from him where it says, oh, there was this very interesting constitutional question lurking in the background, but plaintiffs don't present it. And so I can't reach it. So he's a stickler for party presentation.
Did he say that in the dissent here?
I don't know if he did in this particular case,
but
he hasn't.
He did say it in one of these cases we're talking about.
He has in several cases raised this point that he's not going to reach arguments and claims not raised by the parties.
Yeah.
And other judges have a more broad view that they think that they can reach out and decide based on anything.
Right. Like he says like, oh, the advocate made this argument sort of in passing, but didn't really advance it in the briefing. Yeah. And so I'm not going to decide it.
And look,
I think it's interesting.
As someone who, we have to litigate a lot of cases against the government where there's a weird test in rational basis scrutiny, which is a particular made up judicial doctrine for certain rights that the court since the 1930s have thought is less important than other enumerated rights. But there, the judges sometimes will make up justifications for the government. And as someone who's litigated those cases, there's a frustration that, you had to build out an entire record at the district court. You had to do discovery. You had to take depositions. And then you get up on the Court of Appeal, and now there's this completely new justification for a law. It seems to raise real fairness issues
that the government didn't even think of.
Yeah.
I do think, though, that there is a difference between going out of your way to raise arguments on behalf of the government to preserve the constitutionality of an ordinance or something like that, and taking your oath seriously as a judge and saying, my oath is to uphold the Constitution and laws of the United States of America. And if the parties present me two alternatives, both of which would be in violation of the Constitution, I am not bound by their unconstitutional arguments. I can say both of these things would be in violation of the Constitution. Here's the route that would not be. And I say that because stare decisis is powerful, and we should not be bound by the arguments of parties to determine what the Constitution actually says.
But not to digress into a huge debate here.
But wander off the wrong direction.
But also stare decisis doesn't apply to issues that are not raised, argued, presented, or part of the holding. So if you have a statutory case where a constitutional issue was not raised and the statute's applied, that has no stare decisis value as to whether or not that statute's constitutional in a future case. Because while you do have an oath to uphold the Constitution, that includes Article 3. And Article 3 limits a court's jurisdiction to cases and controversies.
Unless you don't interpret Article 3 that way.
Unless you don't interpret Article 3 that way. And so to a certain extent, maybe by going beyond that to reach constitutional claims that weren't raised by the parties, you're exceeding the case or controversy. So in doing that, you might be violating your oath to the Constitution. So I think judges see it from both perspectives. I happen to be a party presentation guy.
For the most part,
as the listeners can probably tell,
99% of the time I agree with you.
Yeah.
But I think this is like in 0.1% of the cases, you and I would reach a different conclusion. I think 99% of the time you're correct.
Yeah, you're saying it's a little bit like how subject matter jurisdiction can be brought up on appeal or by the judge, because the judge has a constant duty at every point through the case to be faithful to the Constitution. And so he can do it on his own.
Exactly.
Is the other side.
But in fairness, I'm a weak party presentation person as to whether or not it's been raised. So you give me a couple of sentences. Fair.
Which is actually where I draw the comparison to what's going on in this case. The question in my mind is, have you raised that red flag and waved it around sufficiently?
Yeah.
If you've raised the red flag and waved it around sufficiently, whether you're talking party presentation or preservation of an argument for purposes of appeal, as long as the judge sees it and has the opportunity to correct whatever wrong you've drawn attention to, I think that's sufficient.
Yep.
And apparently the majority of the court does too, setting aside some weirdness with habeas standards, because there's always weirdness with habeas standards. All right, finally, let's talk FCC. We've got like 6 minutes. So Clayton, you were there.
I was there. I
saw
it come out of Justice Roberts' mouth.
Tell us what. Okay, so first and foremost, please, our dear listeners, do not fall asleep while we talk about this case. But Clayton, what happened to bring us to the Supreme Court on FCC versus AT&T?
Okay, so there's the Communications Act of 1934, and it allows the FCC, the Federal Communications Commission, to investigate people for suspected violations of that law. And basically, if the FCC thinks that a company, in this case AT&T, is in violation of the law, it can send them, it's like a notice of apparent liability, or it's like an order to that effect. It sends them notification, hey, we think that you have violated the law. Here's the specific facts and law that we think that, support our position on this. And it's called an order. I mean,
it's styled
as an order. Yeah. It tells you, here's what you have to pay.
Here's your fine, folks.
And it's a public document.
And it's a public document. And so the question is, does the process that is afforded to the person or the company that is the recipient of this, does it adequately allow them their right to a jury trial? That the Seventh
under
the Seventh Amendment,
right?
Yes.
Which In order to understand this case, we have to talk a little bit about jarcossy.
Yes.
So, law professor Chance,
yes,
tell us a little bit about jarcossy. We don't need more than we're down to 5 minutes now. So
the short version is that the Seventh Amendment guarantees a right to jury trial for things that what you would have had a jury trial for at common law. So something that's an analog to something at common law. So your standard torts that you would ordinarily get a jury for, negligence, fraud, things that you would pay these penalties for, that you have a right to have that claim, to have those facts adjudicated by a jury rather than
if they exceed $20, the high price of $20.
The high price of $20. And so what jarcossy was about administrative agencies. Administrative agencies sometimes would, instead of going into court, taking you to court and giving you a jury trial on whether or not you violated some federal statute, they would take you through an administrative proceeding, sometimes with huge penalties, millions of dollars on things that look a lot like negligence or fraud or common law contract disputes, but they would be adjudicated by a federal agency in front of that federal agency, which is a real problem for anyone who remembers Schoolhouse Rock, because there in front of an administrative law judge, it's not a real judge. It's someone who works at that administrative agency.
Basically, you have the prosecutor and the judge are part of the same organization, and you don't get a jury.
And you don't get a jury, and you don't get all of the civil protections of like hearsay and all of the other things.
I'm just imagining the prosecutor saying like, "Excuse me," and then like running over to the rope and saying, "Yes, make your arguments." Yeah,
same person, same agents. And so the Supreme Court in jarcossy says that is unconstitutional, that you can't circumvent the jury trial that way, that you are entitled, if it would be something that's analogous to something at common law, you're entitled to a jury, that they can't go around that by using an administrative enforcement proceeding. Broadly speaking, that's the Cliff Notes version of jarcossy.
Which brings us to this case, because here we have, let's just assume for the sake of argument that what's going on here looks an awful lot like a common law dispute. But it's being adjudicated kind of by an ALJ. And if they fail to comply with
there's been an order that they sent.
What happens if they fail to comply with the order?
Well, technically what happens, although you wouldn't know it if you received it because you'd be scared because it says order to pay. Technically what happens if you just ignore it, I don't think there's anything.
It's not self-enforcing.
Yeah. So you have to wait for, you can just sit back and say, this doesn't okay, good for you. I don't care. And wait for the FCC to bring an actual suit, a civil suit in a court.
With a jury.
With a jury. So you actually are, so in between the time that you've received the order and the civil suit in the court has started, yes, you are sort of like, your reputation is being harmed, you're scared, you don't know what's going to happen, but you, as the court believes, you are not being deprived of your Seventh Amendment jury trial because a trial hasn't started yet. And it's always the case that we have to wait for the government to bring a suit against us in order to get our Seventh Amendment jury trial. Anyway, that's always how it was back when the Constitution was ratified. So for the time being, this order itself doesn't violate your Seventh Amendment rights. And that's consistent with jarcossy, because this is just a different set of facts.
And I think the argument that they would make is it looks a lot like a criminal indictment, right? If you've been indicted, there's still that time period before the jury trial. I mean, it's a little bit different.
Mm-hmm. And even the law even says here that, like the statute says that the recipient of this order can't be prejudiced in any other proceeding simply because the order is out there. Like it's just an order, it's just a notification. That's the argument that the government takes. Now, at the beginning of the case, they were trying to say all other kinds of stuff, how it was an order and they have to pay it.
Yeah, so that's one of the things that I think from an advocacy perspective, and this pops up in the oral argument if you listen to it a lot, is the plaintiffs in this case were really frustrated because the government had really changed its position from the outset of the litigation. At the beginning of the outset of the litigation, there were the government's position was like, these are orders, they can be used, they have downstream effects in other proceedings. And the government kind of reimagined what these things are to avoid the jarcossy problem while this case was being litigated. Mm-hmm. And so this is another one of those things where it's frustrating. You get all the way to the Supreme Court and now the government has a whole new theory of the case,
it all ties together,
and it wins on it.
Yeah.
So
And this is an issue so there's one lone dissent. Roberts and everybody else joined, and then Thomas dissented. And Thomas kind of points that out, like, hey, this is really unfair. He points it out for purposes of remedy.
Yeah.
And like equitable, like doctrines of estoppel and stuff, that it's just not fair for the government to be representing itself one way at the beginning and saying, hey, you have to pay all this money. And then later in litigation say, oh, you never actually had to pay it. We never had to give you a jury trial because we didn't actually prosecute you. And Thomas, I think, just says,
this is what we expect litigants to do, is what Thomas says. This is, we expect, in order to challenge constitutional issues like this, you pay under protest, you preserve your constitutional issue, you bring a lawsuit, and then on appeal, if you win, everything gets unwound, you get your money back, and you come back. And Thomas's position is they did everything right. What was AT&T supposed to do under the circumstances?
That shouldn't have had to pay.
And I feel like, in a way, this is going to smack the FCC in the face a lot harder than they expected to, because now they're going to have all of these orders floating out there that are just not going to be paid.
Yeah, because now the law is that those orders that they send out that look real scary can be ignored.
Yeah.
Well, I mean, they're just going to have
to.
I mean, the FCC is going to have to put their money where their mouth is and sue these people if they really think it's worth it. So it puts an onus on them to do a cost benefit, and they can't just go scaring the land.
Yeah.
And getting their money, they have to go in front of a court.
Yeah.
And make it happen, which is fair.
Which is fair. So on this one, at least, it ends up being 8-1. And Justice Thomas, it doesn't sound like he disagrees really with the rationale here as much as he just disagrees with the way that the remedy is non-existent in this case. But I think this, to me, rings a little bit, and now we're working on borrowed time. I'm sorry, everyone. Rings a little bit of the subpoena case that we had from the New Jersey Attorney General issues a subpoena that orders the donor lists to go to the court. And there's that disingenuousness of the government saying, oh, but it's not a real order. Like, it says that it's punishable if you don't, but like, we'd have to bring another lawsuit in order
to enforce it.
We'd have to bring a contempt proceeding. This is a very similar, almost disingenuous argument from the FCC of, it's not really an order, though. We're just suggesting that you pay.
It says order.
You have to do a whole nother proceeding before it's enforceable. And it's important, I think, to say one is an injury for standing purposes.
Yes.
And this is a question of, do you ultimately get that jury trial that you're entitled to? And the answer to that is yes.
And actually, a really notable thing that I can talk about, because I was there and I saw him say it, was Roberts was really emphatic when he was reading this out to sort of suggest to the FCC or whatever government agency it be that these are not orders. Like he says, this is all based on the assumption, the presupposition that these are not orders. You hear me, government? He seemed to say that was the subtext. So
that was the trade-off that got you out of this.
He was very clear, like, okay, maybe agency shouldn't call these orders, or he didn't say that, but that was the implication.
And this is just a weird structure. I don't know about you guys, but I haven't seen, maybe I haven't done enough of this, but I haven't seen a structure that's quite like this anywhere else. So maybe this is just a weird little one-off.
Yeah, the other agencies don't
in the
have
FCC. So, all right. Well, now that we have exceeded our time, thank you both for joining us, and thank you for listening, our beloved listeners. And if you've enjoyed our conversation today, please leave us a review, leave us a comment. We'd love to hear from you, and join us next time for more Rightly Decided.